state of Florida.
May it please the court, Keith Upson for appellant Tyler Bighames. May it please the court and counsel. Good morning. It occurred to me this morning I'm not entirely confident that it's pronounced Bighames. So to the if I'm wrong about that, if the family's watching this or watching it later, I apologize. I'd also like to apologize to the court and counsel for a Scrivener's error that I had discovered in the 11th hour in the original initial brief. Counsel and the court likely caught on to my misuse of the word aggravated battery 3 times in the last page of the second issue on appeal, when in fact what I meant to say was aggravated assault. That was corrected in the amended brief, which I also apologize to the court and counsel for the late filing of the request to amend the brief. I don't anticipate it will change my argument this morning to any extent beyond simply where I would have said count 4, I would now say counts 1 and 4. And with that, I'd like to start in reverse order with my second issue on appeal, the legal inconsistency of counts 1 and 4. And to do so, I need to recede somewhat from the position I took in the reply brief where I cited this court's decision, Proctor, and won't say concede, but recede some. Specifically, I said Proctor was on all 4s as an acknowledgement to the accuracy of counsel's argument in the answer brief, that what's different is that here Mr. Bighames was charged also as a principal.
And let me ask you about that. If the principal theory applies here, then does it really make a difference about the jury finding that he didn't have a firearm in his hand?
Judge, I think it makes a difference because our 2 issues are intertwined because of that jury's finding. I think when the jury expressly found he didn't possess.
But could he not still be a part of a criminal episode?
He could, Judge, but I think it's a little one step further than that. I think the only theory under which the jury could have convicted on all 4 counts was as a principal, but the legal inconsistency is to counts 1 and 4 because counts 1 and 4 expressly include an element that necessitates possession of a firearm. So the concession to counsel is Proctor's not on all 4s, it's on 3 out of 4, the 4th ban. Judge Morris, I believe you wrote that.
Well, Proctor wasn't a principal case, right?
Because it wasn't a principal case. So to the extent it's true that the only way the jury could have convicted him on counts 1 and 4 was as a principal, then that sets up my position as to the first issue on appeal, that the denial of judgment of acquittal as to all counts. Because there were 2 theories that they could have convicted, that either he actually possessed, which was consistent with her testimony.
Well, we have the one witness who was at the scene named Karen, whatever her last name was.
Starts with a D.
And she's got a firearm in all 4 of the individuals' hands, based on what she testified to.
She does, Judge, and she was pretty consistent about that.
Well, in this case, though, Mr. Bighames was found on the lanai, shot with a firearm sort of beyond his grasp. I mean, this same witness that Judge Black has just talked about saw all 4 of these guys show up. One of them huddled her into a corner, and 3 of them shot out the glass and went inside.
That was her testimony.
And then 3 of them left, but Mr. Bighames, at least we know, is connected up by the DNA as being the person who was left on the lanai who was shot. But the weapon that was found just outside of his grasp, the casings of his weapon were found inside the house that matched his weapon. So the DNA puts him as the person on the lanai, puts a firearm just beyond his reach where he fell. The firearms matched up to the casings that were discharged, and the eyewitness said she saw all 3 of them shoot out the the sliding glass doors, and they were all armed and went in there. Seems like a lot of evidence to me.
It was a whole lot of state's case there, Judge, all in one, and of course I'm trying to put placeholders to go back. I mean, obviously, it was a DNA match, and the most likely explanation for that, because she testified she saw someone, the third, as he exited, the straggler, fall in that spot. The most likely inference to be drawn from that is that it's because it was Tyler, and Tyler was bleeding there. But this case almost smacks of a situation where the prosecution got greedy, where they went a bridge too far, or in this case, a count too far in trying to seek that fire enhancement. Because Your Honor did just, to my reading of the record, correctly recite this one witness, the only eyewitness, the only person who was there, her testimony. And even further, she said when all four approached, all four had guns. And the one who stayed with her had a gun. He never went in. That the three, as the court said, began shooting in the glass. Two exited and left, and the third, the straggler, is the one who fell in the location where Mr. Bighames' blood, or where the DNA tested positive for him. But the jury said he didn't have a gun. And I can't reconcile those two other than the fact that...
Well, but again, he from taking everything in the light most favorable to the state, Bighames was inside the house, was shot. The two individuals who were not the attackers were both shot inside the house. The spent cartridges that are found where those guys are shot matches the gun that's right next to Bighames. I mean, it seems to me he's up to his neck in a criminal episode here. He's in the house, actually three people are shot, him and the other two guys that are in the house. His DNA is right outside the door, so to speak. He's dropped off at the hospital with gunshot wounds. I mean, I don't see how you avoid the principal theory, even given the jury's finding on the firearm. So what? So if he didn't have a gun, what difference does it make?
Makes a big difference, Judge.
There's probably enough evidence to connect him to this crime without the principal theory.
To connect him to it. But under the principal theory, like counsel argued below, they were required to show, and it's essentially about the state's burden. The denial of judgment of acquittal, the sufficiency of evidence, and our consistent, so I'm not going to waffle on that. There was no evidence of any contribution he made to this endeavor. He was present and he fled at worst.
Well, based on her testimony, he's one of the three people that were charged through the doors with guns blazing.
Well, Judge, the jury rejected that he had a gun.
But not that he wasn't in the house. We don't know about that.
And it's not mere presence. The evidence doesn't show mere presence. Mere presence would be if he was standing out on the lanai while this all went down. That would be mere presence. He was actively present. He charged through the house with the other two.
Well, Judge, and it's not clear to me from this record that the state met their burden of demonstrating that he charged through. Notwithstanding the fact that the most likely inferences to be drawn from the evidence is that he was present in the house. But once he was unarmed and present in the house.
These were two other guys who shot the inhabitants of the house.
Well, and Judge?
Because we know that it wasn't their guns that were fired.
Well, and the police report, everybody's shooting at everybody, and of course the police report's not trial testimony, and even from her testimony about her position and bullets whizzing by, it could very well be the case.
But the ballistics evidence showed that the two victims in the house, guns were never discharged.
That was law enforcement's testimony at trial, Judge. That's correct. Because when I got to that section in the answer brief, and there's no record cite in it, no cite to the transcript, boy, I got ready to go refute that. And of course I can't, because that was the officer's testimony. But we can't overlook the fact that Mr. Bighames got shot. Because Mr. Bighames getting shot, well, apparently because none of the other firearms in the house were fired, or this third-party drug buyer that none of us know anything about. We don't know who he is, we don't know where he went, we don't know how armed or unarmed, we don't know.
Which supports the idea that he was in the house.
He was in the, even if we concede he was in the house, once he's unarmed coupled with the fact he was shot, but for the mask, makes him as likely to have been a victim or hostage as it does a principal who in some way materially contributed to what took place inside the house. I know it's a stretch. I know it wasn't raised below, but it's the state's burden to provide that evidence that he did something. And if he was unarmed and entered with the men who were, and ultimately got shot, we don't know what happened in there. And not knowing what happened, if they hadn't sought reclassification, if they hadn't given the jury an opportunity to say, you know what, no matter how many times
Go ahead.
no matter how many times she said all four had a gun, we don't think he had a gun. And once they've said it, we're all stuck with it.
I guess this isn't in the record, but I was surprised that apparently nobody ever identified the other two people that were involved, or other three people. It was Bighames, not, we don't know that. That's not of record.
I thought it was, but I would not have focused on it. So as I stand here, I don't recall.
I didn't see anything in either brief about it. It doesn't really make that much difference.
I don't recall, Judge. I appreciate that's a lot of speculation on my part from the podium that was never presented to the jury. And this court's one logical conclusion this court might reach about that, because obviously a judgment of acquittal argument's being made prior to the jury expressly finding he didn't possess a firearm. You know, the rule provides for a third written motion for judgment of acquittal.
This argument you've made now, was it preserved below?
The insufficiency of the state's evidence as to the principal theory?
He arguably was some sort of hostage or was acting contrary to the others?
No.
This is the first I've heard of that.
But it's the state's burden to prove that he did some act in furtherance. And what counsel did say, and in that lengthy motion for judgment of acquittal that I attempted to include verbatim, because I felt contextually it was necessary to get to the parts that made sense, to have the whole. He talked about the example where if you have four individuals, the state has to show, well, this one drove the car, this one held the door open, this one did this one. It's like, it doesn't have to be much.
Was the inconsistency of the verdicts, as you argue, was that preserved below?
No, Judge, it wasn't. But the legal inconsistency of the verdicts is useful for us on appeal only to the extent that it eliminates one of the two theories by which the jury could have convicted on counts 1 and 4 and leaves only the principal. And on the judgment of acquittal, it was directed toward all counts and specifically challenged that the state hadn't shown that one action further. So the argument about maybe he was a hostage, no, none of that was ever raised. It was never presented to the jury. My point only being, at no point does the burden shift. We don't know. We don't know why Tyler had the mask on, why he entered. We don't know who shot. We don't know if he shot himself. We don't know. And for whatever reason, the state chose not to call the two individuals whose names I don't recall, but I've endearingly come to refer to internally as the drug dealers, the two residents. So simple from an evidentiary perspective in hindsight to have resolved that, but no one who was inside testified at trial. And the reality is we don't know, and we don't know is not enough. The state had an obligation to affirmatively show Tyler did something in furtherance. And so that's why legal inconsistency remains relevant, because the only theory then, rejecting that Tyler had a gun, the only theory under which the jury could have convicted him on 1 and 4 was principle. And principle as to all 4, they simply didn't show enough. Looks bad. The mask, probably the worst part. But the getting shot part, that is as consistent with him refusing to engage in the dwelling as it is him actively shooting in the dwelling. And
You're right at your 15 minutes.
Well,
just so
I
you
couldn't
know.
recall if I'd reserved or not, but I was going to stop there regardless, Judge.
Okay.
Thank you.
Good morning. May it please the court and counsel. As to the first issue that...
Well, before you go there, did they preserve the argument below about the inconsistent verdicts? Was there a contemporaneous objection following the rendition of the verdict?
No, and the reason for that probably is because this is not an inconsistent verdict. What appellant is pointing to, talking about, it's inaccurate to say that the jury did not find an element of the crime of aggravated battery. I brought a copy of the verdict form. What this is a special interrogatory verdict. This is for sentencing purposes under the 1020 life statute, which is 775.087. Under Apprendi, the state is required to put this language in. These are special findings of fact that have to be made by a jury in order to reclassify the crime of aggravated battery from a second-degree felony to a first-degree felony, and also invoke the minimum mandatory minimums. I believe for this one it would be a minimum mandatory of 20 years. So this isn't inconsistent. This is a separate finding of fact. So that's why it is not an inconsistent verdict. Also, under theory of principle, the state did provide sufficient evidence to find that...
Well, without the principal theory, it would be inconsistent, wouldn't it? I mean, he was convicted on count 1 of shooting into a dwelling with a mass, so if there was no principal theory, how could he be guilty of shooting into a dwelling if the jury also finds that he has no firearm?
Well, I provided the court with the case of Birch v. State, which is out of the 4th DCA, which goes through the analysis of the 1020 life statute, and the findings, these findings of fact about whether somebody actually possessed a weapon, that language is only included for the purposes of sentencing and don't negate any kind of findings that the principal or not, that the appellant is guilty of aggravated battery, is guilty of aggravated assault. This is a totally separate issue, and as the court points out, the reason, and the Florida Supreme Court has also pointed out, is that when the state does the verdict in this way, where they have, you know, the appellant is guilty of shooting within a building, these questions about under the 775 under the 1020 life statute really should be separated out into a whole other form, because ultimately those findings are separate and apart from the jury's findings of the elements of the crime.
So the fact that they don't find that he has a firearm in his hand for sentencing purposes, it cannot be applied to the
No.
to the verdict, in analysis of the verdict?
No. And Birch versus State is very clear on that, and also the cases that that Birch cites from the Florida Supreme Court. These are two totally separate findings. And also, as counsel pointed out, he talks about that this is about enhancement. So he acknowledges that these separate findings are about whether or not they're going to enhance the sentence for the aggravated battery. As far as we don't know what happened, that's really not the standard. The standard is whether or not the state has provided competent substantial evidence to submit the issue to the jury, and that a verdict could stand. So, under the facts of this case, we don't merely have Karen Downey talking about these 4 gunmen coming on. As the court has demonstrated, you have a pretty good grasp of the facts that we have law enforcement testimony that they see the men shot, pictures are introduced, these men have been shot. The casings from the bullet come from the gun that was found on the lanai. Appellant left biological matter containing his DNA on the lanai. All of these, and in fact, the evidence, they didn't even need a principal theory, but they did. They used the principal theory, and there is sufficient evidence to convict Mr. Bighames under a principal theory. I did want to request, council did submit an amended initial brief, which this court accepted yesterday.
Did you see the order we issued late
I
yesterday?
did, and what I'm asking this court to do is, in lieu of me submitting a written amended answer, I would ask that the court rely on the arguments made here at oral argument
That's
to
fine.
resolve the
Yeah,
issue.
that's fine.
Okay.
That's fine. We know you kind of got at the last minute, and your opposing counsel realized he kind of did that to you, but it didn't appear to materially change
No, sir.
the substance of these arguments, so we didn't feel that you'd be prejudiced, and if you don't want to file that written brief, that's fine. We'll take your oral comments.
Okay.
Okay?
Because my position is that, the state's position is that as to the shooting within the dwelling, the evidence shows from Karen Downey's testimony and through the forensic evidence that that the appellant was one of the shooters. He was part of the whole criminal scheme. It was up to a jury to decide whether or not all the other crimes that occurred were reasonable foreseeable. It does seem reasonable foreseeable to me that if you shoot into somebody's house, somebody is bound to get shot. If you shoot a gun, somebody is going to get shot. And then again, as to the shooting within a dwelling, these findings under 775.087 that the jury is required to make under Apprendi have nothing to do with the underlying crimes. If the court has no further questions for me, I'll rely on the merits of my brief. And as to the shooting within a dwelling, the arguments made here at oral argument. And I'll ask that the court affirm the appellant's judgment and sentence.
Thank you. Mr. Upson, you got 5 more minutes.
I likely probably should have spent more time with that first district case, because the key words to me were always the underlying crimes, which in this case would be the aggravated batteries. Counts 1 and 4 being separate charged offenses, and if I'd read it more closely, I might be able to more carefully flesh that out and distinguish it. So to the extent the decision is inconsistent with what I'm saying now, of course the First District's decision says what it says. My concern, and why I said perhaps this was an example of prosecutorial greed, is that one question too many. So notwithstanding the fact that that special interrogatory is necessary to reclassify the aggravated batteries, once you ask the question, we all have to live with the jury's factual answer. The jury's factual answer was, notwithstanding how many times Ms. Downing said all 4 had guns, that Mr. Bighames did not. And the complication that created for this case, we continue to maintain, means that absent the principal theory, so if this were under this court's decision in Proctor, that counts 1 and 4 simply couldn't be sustained, that the only way to get there was through principle. At the end of his argument for judgment of acquittal, counsel argued, and this is bottom of page 4 and top of page 5 of the initial brief, and it looks like transcript pages is included within 509 to 512. His example that I was referring to earlier, the state had to show, okay, you held the door open and you shot somebody. Obviously 4 things that furthered the crime, no matter how small. There it is. They don't have to identify each person, and they don't have to identify what each person did, but they do at a bare minimum will have to identify that each person did something. Once the jury factually took the gun out of Mr. Bigham's hands that left the mask and the entry, really, to explain away. And if he was the one who was unarmed, the mask and the entry become more difficult for the state to show that jury he took some action in furtherance of this episode. I had started to say before, and I don't know if I finished the thought, this court might fairly, of course, rhetorically, respond to that argument with the fact that there is a rule that provides for a written judgment of acquittal after the verdict. That at the time counsel was arguing for his judgment of acquittal, the jury hadn't yet expressly found that Mr. Bighames didn't have the firearm. Wouldn't the best vehicle for the argument that we're making now have best been raised in some form of post-trial written motion? And rhetorically, if the court hypothetically were to ask me that question, I think I'd have to concede, yes, I think that would probably be the vehicle best suited for the argument that we're advancing. But of course, the record is silent because that wasn't preserved, it wasn't done. And we have the argument that we have. I think his JOA argument still holds water, particularly in light of the fact that the only way to get there on 1 and 4 was through principle. But I think the state simply didn't show this jury enough, even under the principle theory, and that's why we're asking that the court reverse and remand.
Thank you.
Thank you.
Thank you both very much. Your argument